So we're just starting the YouTube live, and I request everyone to kindly keep the mics on mute. Whatever question and answers are there will be a time for that towards the end of the class. And we'll also start the recording of the class, just in case. Right. So, hello and very good morning, everyone. We very warmly welcome you to another class of Vestralex free online community classes on law initiative. We hope this initiative has been contributing to you constructively in your career and in your life otherwise. Again, it's only possible with the kind blessings of our seniors, guides, and mentors, and who come with us and discuss various very interesting, very unique topics on law, which are in themselves very complex. But as I've been able to understand from whatever my friends who have been able to use YouTube and such webinars have told me that these have constructively benefited everyone in exploring new domains of law and understanding new topics, enhance their arguments and so in this respect itself, today to take this journey forward with us, we have Shri Manoj Kumar Mishra, sir. He's a senior advocate of the Orissa High Court. So sir is going to be talking about directive principles and so briefly just speaking about sir, sir was enrolled as an advocate in the year 1978. He was designated as senior advocate by the full court of Honorable Orissa High Court in 2011. Sir has more than 43 years of practice in Orissa and other high courts and Supreme Court in various tribunals. Sir has been a former member of the Orissa State Bar Council for about 20 years. He was also formerly member of the Disciplinary Committee of the Bar Council of India from 1997 to 2002. Sir has been awarded various distinguishing excellence awards, such as the Professional Excellence Award from the Governor of Orissa, and again various other prestigious awards. So I cannot obviously suffice, and I cannot give a very elaborate introduction for sir. That will require another class in that respect. But without any further ado, I hand over the class to you, sir, and I welcome you, sir. And we are all very grateful and deeply keen to learn about the directive principles of state policy from today. So your mic is on mute, sir.
Thank you, Kesavji. So you have given a very difficult task to me. Actually, that is really a very contentious issue. But still, I'll try my best because actually, I will start with introduction of directive principle of state policy. Later on, I will say it as DPSP because in short, it will be better known as DPSP. Directive principle of state policy always not possible to refer to always that long words. So, by the directive principle of state policy and the guidelines to be followed by the government of India for the governance of the country. Of course, it is Article 37. It clearly is not enforceable by any court, but in course of different judicial process, Honorable Supreme Court and different high courts, in some cases they have brought into the scope of Article 14 and 16 and Article 21 of the Constitution of India and made it enforceable to some extent. And I will also deal with different legislations. Different legislations have also been framed by government to government of India as well as different states to in furtherance of this satisfying the principles of directive principles of state policy. So they are not. It is true that not enforceable in court, but the principles laid down therein are considered to be fundamental in the governance of the country, which makes it the duty of the state to apply these principles in making laws and to establish a just and in the just society in the country. Actually, the little bit background will be there, the history will be there. why this DPSP came into it. DPSP is the short form. Sorry, Mali? Sorry? No. So, but both the fundamental rights and the directive principles of state policy were included in the first draft constitution in February 1948, and second draft constitution in 17th October 1948, and third and final draft constitution on 26th November 1949, prepared by the drafting committee. While debating on DPSP, in the Constitution, Dr. B.R. Ambedkar is the father of the Constitution, stated on 19 November 1948 as given I'll quote his words. It is the intention of this assembly that in future both the legislature and the executive should not merely pay lip service to these principles enacted in this part, but they should be made the basis of all executive and legislative action that may be taken thereafter in the matter of the governance of the country. That was the fundamental preamble laid down by Dr. Ambedkar while providing directive principles of state policy. Directive principles of state policy aim to create social and economic conditions under which the citizens can lead a good life. They also aim to establish social and economic democracy through a welfare state. Though the directive principle of state policy are non-justiciable rights of people, but fundamental in governance of the country. It is a very thin line of distinction. I'll explain subsequently. It will be the duty of the state to apply these principles in making the laws as per Article 37. Besides, all executive agencies of the Union and State should also be guided by these principles. Even the judiciary has to keep in mind in deciding cases. And in fact, judiciary has kept in mind in deciding several cases. I'll deal with later on. An existing policy in line with DPSP cannot be reversed. That is the policy frame means that cannot be reversed. That is the most important aspect. However, it can be expanded further in line with DPSP. This policy changes applicable under DPSP shall not be reversible unless DPSP itself is amended. Because that is, so far as amendment is concerned, there are different provisions, different judgments of this of the Honorable Apex Court in that line. But I'll deal with, and I need not necessary to deal with right now at this time. The directive principle ensures that the state shall strive to promote the welfare of the people by securing a social order with social, economic, and political justice is animated and informed in all institutions of life as per Article 38(1). Dr. Ambedkar again clarified it. I'll just quote Dr. Ambedkar. The word strive, which occurs in the draft constitution in judgment, is very important. We have used it because our intention is even when there are circumstances which prevent the government or which stand on the way of the government giving effect to these directive principles, they shall, even under hand and on propitious circumstances, always strive in the fulfillment of these directives. That is why we have used the word strive. Otherwise, it would be open for any government to say that circumstances are so bad, that the finances are so inadequate that we cannot even make an effort in the direction in which the constitution asks us to go. Because the government, different government may say that we are finances is so inadequate that we cannot act in accordance with the directive principles of state policy. That is the reason why Dr. Ambedkar has given this introductory speech. Background, I will show you the background of this, how it came. The source of concept of directive principles of state policy is the Spanish constitution, from which it came to Irish constitution. The concept of DPSP emerged from Article 45 of the Irish constitution. The principles have been inspired by the directive principles given in the Constitution of Ireland, which are related to social justice, economic welfare, foreign policy, and legal administrative matters. The directive principles of Indian Constitution have been greatly influenced by the directive principles of social policy. The idea of such policies can be traced to the Declaration of Rights of Man and of the Citizen proclaimed by revolutionary France and Declaration of Independence by the American colonies. These are all from where this concept has been imbibed. Classification. Now, directive principles are classified under different categories: economic, social, listic, political, administrative, justice, and legal, environmental, protection of monuments, peace and security, constitutional provisions, and Part 4 of the Constitution of India, Article 36 to 51, contain the directive principle of state policy. Directive principle of state policy aim to create social and economic conditions under which the citizens can lead a good life. They also aim to establish social and economic democracy through a welfare state. Though the directive principles are non-justiciable rights of the people, but fundamental in the governance of the country, it shall be the duty of the state to apply these principles in making the laws as per Article 337. Besides, all executive agencies of the Union and states should also be guided by these principles. Even the judiciary has to keep them in mind deciding the cases. Article 37 of the Constitution of India states that application of the directive principles states about the application of the directive principles of state policy. These principles aim at ensuring socio-economic justice to the people and establishing it as a welfare state. Why I am stating all these things, because I am told that the listeners are not only lawyers but also they are from different status of life. That is the reason why I'll have to give the detailed background of which where from this DPSP came and how it was thought of everything. The fundamental rights versus, now there's a dispute of the fundamental rights versus DPSP, because as may read Article 37 for a minute, then I will go to the Article 37 clearly says the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply this principle in making laws. So, though it is not enforced, just like fundamental rights, it cannot be enforceable, but it can be enforced in a different forum by different legislations and different policies and all that. And that is the reason why there is always a fight between the difference between fundamental rights and directive principle of state policy. Unlike the fundamental rights, the scope of DPSP is limitless and it protects the rights of the citizens work at a macro level. Because fundamental right is limited to very limited. DPSP expands the horizon like anything. DPSP consists of all the ideals which the state should follow. Statements is follow and keep in mind while formulating policies and enacting laws for the country. Directive principles are affirmative directions. On the other hand, fundamental rights are negative and prohibitive in nature because they put limitations on the state. But here, DPSP doesn't provide limitations on the state. It enhances the scope of the welfare measures by the state. The DPSP is not enforceable by law. It is non-justiciable. It is there fundamentally, but it is not subordinate to the fundamental rights. When the brawl for supremacy between fundamental rights and DPSP came up before Supreme Court in the case of State of Madras versus Champakam Dairanjan 1951 SCR 525. First it came to Supreme Court on this issue, because our constitution was promulgated in 1950. Thereafter, first judgment is this of the Honorable Supreme Court. The court said the directive principles have to conform to and run subsidiary to the chapter on fundamental rights. Letter in the fundamental rights referred to above, the majority opinions reflected the view that what is fundamental in the governance of the country cannot be less significant than what is significant in the life of the individual. Another judge constituting the majority in that case said, in building up a just social order, it is sometimes imperative that fundamental rights should be subordinate to DPSP. Most important, it is the matter that the fundamental rights should be made subordinate to directive principles of state policies. Again, in state of Kerala versus N.M. Thomas, Justice Krishna, the famous judge, speaking for the majority, said DPSP have, through important constitutional amendments, become the benchmark to insulate legislation enacted to achieve social objectives as enumerated in some of the DPSP from attacks of invalidation by courts. This way, legislation for achieving agrarian reforms and especially for achieving the objectives of Article 39B and C of the Constitution has been immunized from challenge as to its violation of right to equality, Article 14 of the and freedom of speech, expression, etc., Article 19. However, even here the court has retained its power of judicial review to examine if, in fact, legislation is intended to achieve the objective of Article 39B and 39C, and where the legislation is an amendment to Constitution. Whether it violates the basic structure of the Constitution. Likewise, courts have used DPSP to uphold the constitutional validity of statutes that apparently impose restrictions on fundamental rights under Article 19, freedom of speech, expression, association, residence, travel, and to carry on the business, trade, or profession as long as they are stated to achieve the objective of the DPSP. These are the initial days when the Honorable Supreme Court has dealt with the directive principles of state policy. Thereafter, a lot many judgments have come up, but these are the basic where the substantial ground was laid on this interpretation of directive principles of state policy, how it will be applicable and not. The classification of directive, now let us come to classification of principles. Classification of principle is that it is based on socialist principles, Gandhian principles, and liberal and intellectual principles. These three principles are the basis of directive principle of state policy. So I'll deal with the articles related to this policy principles individually. Article 38, that is the state to secure social order for promotion of welfare of the people. Article 38. What the Article 38 says, the state shall strive to promote the welfare of the people by securing or protecting a social order, by ensuring social, economic, and political justice, by minimizing inequalities in income, status, facilities, and opportunities. Of course, nowadays it has not been followed strictly by the state or the government at any point of time. The inequalities are being inequalities are being growing day by day. But still, our constitution has thought about so, that the constitution makers have thought about so, that to limit the inequalities among the Article 39 says the principles of policy to be followed by the state. The state shall in particular direct its policies to provide towards securing right to an adequate means of livelihood to all the citizens. The ownership and control of the social material resources shall be organized in a manner to serve the common good. The state shall avoid concentration of wealth in a few hands. Equal pay for equal work for both men and women. Health and strength of workers, men and women, and child are not abused. Children are not giving opportunities or facilities to develop, and children and youth are protected against exploitation. I'll deal with these aspects later on in details. I'm just giving the broad outlines. Article 39A, equal justice and free equal aid. The state shall secure that the operation of the legal system promotes justice on the basis of equal opportunity and shall in particular provide free legal aid by suitable legislation and schemes or in any form of on any other way or any other form to answer that opportunities by securing justice are not denied to every any citizen by reason of economic or other disabilities. Actually, our constitution makers have that have very noble thought, but practicality comes it's not very practically. Then it has not been practically it has not been implemented properly. Article 41, right to work, right to education, and to public assistance in certain cases. To secure a right to work and education and to public assistance in case of unemployment, old age, sickness, and disability. Old age. Now I'll tell you the what are the schemes. Article 1, what are Article 1 for Rally, what are the schemes government have been trying to implement the policy. The old age pension scheme. This scheme is implemented as part of the National Social Assistance Program of the Ministry of Rural Development, Government of India. It is a non-contributory scheme and provide a monthly income for citizens or to refugees above 60 years which have no other source of income. Maintenance of another Welfare and Parents and Senior Citizens Act 2007. The Act contains enabling provisions like protection of life and property of senior citizens, better medical facilities, setting up of old age home in every district. It also recognizes the right of the senior citizens to live a life of dignity. The Act provides for financial security to the parents and senior citizens and can award maintenance to the parents if they are not properly cared for. The Act also has provisions of punishment of with imprisonment up to 3 months and fine up to 5,000 or both for children and relatives who abandon their senior citizens. Because nowadays, frequently we see that senior citizens are being neglected, though their children are well off. Recently, we got a news where the old parents they committed suicide because they're not properly taken care of. They're not given food either. Where their son was the rich man worth more than 130 crores. But such instances are rampant at large. But that is the reason why the government thought it proper that in furtherance of implementing the Directive Principal State Policy to come out with this act, maintenance of welfare. And there are many instances, different high courts have delivered judgment, also Florida has delivered judgment in that respect, if that is coming in newspapers now and then. Another important Unorganized Workers Social Security Act 2008. That is an important enactment the government has made. That this act was enacted with an objective to ensure social security, good well-being, and to protect the unorganized sector workers from several contingencies. Because the organized sector, they are covered under International Disputes Act and other statutes. But as far as unorganized things like building construction and bridge construction and other mining and other places, these places they are not covered under this. That is the reason why the government wanted to include those type of workers in that within periphery of the act, the Unorganized Workers Social Security Act 2008. This act is a significant initiative taken by the government to address and provide remedy to the plight of the workers engaged in the unorganized sector for the first time, and to act and has been enlisted several welfare schemes which can be availed by such. It is very difficult to state about the details about because the time is short and it is not possible also. But these acts can be seen that this particular act has a is a milestone for improvement of the life of these unorganized workers. In Article 42, provision for just and human condition for work and maternity relief. The court shall make provision for seeking just and human condition of work and for maternity relief. The government has come out with this act, Maternity Benefit 1961, an act to regulate the employment of women in certain establishments for certain period before and after childbirth is to provide maternity benefit for under different. Now the government has decided to give at least 6 months of holiday for this maternity holiday to the mothers after childbirth. Equal Remuneration Act 1976 have been also made to protect the interest of women workers. It is an act to provide for the payment of equal remuneration to men and women workers and for the prevention of discrimination and on the ground of sex against women in the matter of employment and for matters connected therewith with or incidental thereto. And there also another thing is now after that Bisaka judgment in Supreme Court, and the secretary has also come out with a act, the Women Protection Act, which deals with the harassment to women in the workplace. The 2013 came out with the act, and that act clearly provides if there is a sexual harassment to women in workplace, there is a separate committee is constituted and permanent committee is there. Permanent committee is to look into the consideration if that can be treated disciplinary proceeding also. If ultimately it is that found that the person is guilty of that offence, then he can be punished. Then Factories Act. Factories Act is another milestone act, and way back 1948 when there was no directive principle of state policy. The Factories Act is a social legislation. Factories Act provides many security to the workers, especially when at workplace is concerned, several protections in workplace also. But it can be said that the 1948 is also, though it was promulgated prior to the Directive Principle of State Policy was enacted in the when Constitution was promulgated, but still it can be said to be part of Directive Principle of State Policy. It's a social legislation and it has been enacted for occupational safety, health and welfare of the workers at workplaces. The objective of the act is to regulate the conditions of work in manufacturing establishments coming within the definition of the term factory as used in the act. Then another important is Employees Provident Fund and Miscellaneous Provisions Act 1952. This is another milestone. The act is to provide for institution of the Provident Fund, Pension Fund, and Deposit-Linked Insurance Fund for employees in factories and other establishments. Because suppose the government employees are concerned, they get General Provident Fund. The government employees are always secured and they're get much more benefits from the government. But so far as workers or persons working in private sector, they do not get much that type of protection and all that. That is the reason why their future is always insecure. The government employees, they get a pension. They used to get pension earlier or prior to 2004, but after 2004 they are covered under the NPS scheme. But here it is a statutory benefit available to the employees post retirement or when they leave these services. In case of deceased employee, that dependent will be entitled for the benefits. Actually, in this case, under this particular scheme, some amount will be deducted from employee's salary, and say equal amount will be paid by the employer and deposited before the Provident Fund Commission. And on retirement or on death or on completion of the scheme, the person will get a lump sum amount from the Provident Fund Commission. With that will carry also the interest. Interest is little bit higher than the bank interest always. Under the Employees Provident Fund scheme, both the employers and employees have to make their contributions. Interest and will be added to their deposit and all that. The Workmen's Compensation Act, that is of course of 1923. This Workmen's Compensation Act, I have included Workmen's Compensation Act because it's a very, very important statute which deals with this Directive Principle of State Policy and law. Because a worker, if injured or death is caused in workplace or while doing work or while going to work or coming out of the work, then he will be entitled to compensation. He or she shall be entitled to compensation. That is under Workmen's Compensation Act. That compensation, besides the other benefits which he or she gets from other statutes. So Workmen's Compensation Act, therefore I have included Workmen's Compensation Act 1923, which is a part of Directive Principle of State Policy. The Act to provide for the payment of certain classes of employees to their workmen of compensation for injury by accident. The main of the Act is to provide protection of the workman from injuries and losses caused through an accident in course of and in arising out of the employment is subject to specific expectation as mentioned in the Act. Because most of the time, the private employers, they forget the workers after he is injured, become incapacitated, or after his death. So to make them liable, this act had came into force in 1923, and it is still holding. It is being, it has gained its importance from time to time, and actually the workers are getting a lot of benefits out of that, because the statute is very clear. Once a compensation, suppose a worker is awarded a compensation of about 3 lakhs. If the employer wants to file before wants to file appeal against that order, then he has to deposit the entire amount. That is conditional precedent. He has no, he has to deposit rupees 3 lakh. After depositing only, his appeal will be considered for on merit. Otherwise, appeal cannot be considered. So the moment appeal is dismissed, the workman will get the amount. Not the workman will have to run after the employer to get the amount. That for that reason, this statute is very important. Then Article 43, living wage, etc. for workers. That is most of Article 43. The state shall endeavor to secure all workers in living wage and a decent standard of life itself secure. Now it has been brought into Article 21 of the Constitution of India. This has been brought to Article 21 of the Constitution of India, but now it is broadly covered under Article 21 of the Constitution of India. It shall secure the conditions of work, ensuring a decent standard of life and full enjoyment of leisure and social and cultural opportunities. And in particular, the state shall endeavor to promote cottage industries on an individual or cooperative basis in rural areas. Article 43A, principal participation of workers in management of industries. The state shall take steps by suitable legislation or in any other way to secure the participation of workers in the management of undertakings, establishment or other organizations engaged in any industry. Actually, by this process, what has happened? The management, the employers, the union's representatives are being made members of the management. Being members of the management, gradually by this process, the workers are also getting representation in management. Labor reforms. The following acts were enacted to protect the interests of labor sections of the society. Now, to furtherance of this Article 43A, Minimum Wage Act 1948. Again, it is prior to the promulgation of Constitution. Still, it has got its relevance. It is to provide minimum rates of wages in certain employment, and the minimum wages have been determined and defined when the stated specifically with different governments, both central government and different state governments, under different notification. Almost every 6 months or so, different state governments or the state central government, they come out with what will the minimum wage payable to the workers. With highly skilled, they have categories: highly skilled, unskilled, like this. So apart from the state government have also fixed minimum wages. Payment of Wages Act 1936. That is also prior to this promulgation of but that is most important. The payment of wages. By this process, these workers, they get statutory right to get their wages and also to minimum wages. The act was enacted as to regulate the payment of wages to certain classes of persons employed in USA. The Payment of Wages Act of 1936 governs how wages are paid to employees, direct or indirect. The statute is intended to protect employees from unlawful employer deduction and of unjustifiable salary. Here I will give only small example here. Recently, I was doing a case in Orissa High Court. A group of pump drivers. They operate the pump in this village panchayat areas. Because they have to supply, that is required for 24-hour water supply to villagers. So what happened? The government had appointed a payment of 500 rupees per month. And unfortunately, they were asked because they're very poor and there were no alternative. They're basically illiterate and unemployed. So they had no alternative but to work for five. They had to accept the employment for 500 rupees. And interestingly, they had to work for 8 hours. Not that it is as and when required. It requires 8 hours, and they have to remain present all the time near the. That is the requirement of the work. So even that also they stopped for some time. But after some time, they also when the plea that finance has not come and all that. So group of persons came to me, said that, sir, we cannot afford your fees, but we have this difficulty. I said that don't worry about the fees, but we'll try to do it. I filed a writ application before this High Court. Though I knew that Payment Minimum Wage Act is there, minimum wage separate procedure is followed, separate forum is provided. Still, I filed a writ application before the Honorable Court saying that alternate remedy is no remedy because we have to implement our statutory right of Article 21 itself. Not only that, Article 21 itself. So I filed it under Article 21 of the Constitution of India, and to 26 of course, but applying to Article 21. The application was that there was interim order. Interim order, the Honorable Court directed that they shall be paid minimum wages as notified by the state government from time to time. So that also not paid. Unfortunately, the none of government, even high officials, they turned deaf ears to the claims of this, even to the interim order passed by the court. Then what happened? I filed content application. Content application, the court took very serious view and called personal appearance of finance secretary as well Panchayat secretary in person. In person, they very interestingly they came. They said that no, it is not just possible. We cannot give it, even if High Court has passed this order. Not possible for us to implement the order because it is not under the scheme. Then thanks, both the judges have retired in the meantime, but they thanks us. They fired up. They said that, what do you say? Then that you cannot do, you have the audacity to violate the order of this court. All right. Asked the local IIC to come and arrest them because they have themselves in front of the judges. They said that they will not implement the order. Then, thereafter, the Advocate General came. They said, "So, sir, please excuse us. Excuse them. We will implement it." No, just implement it by 2 o'clock. You come with the order, then only we can consider. At 2 o'clock, they came with the order that yes, the minimum wages will be paid. Thereafter, I said that no, because they will not be paid even if they come out with the order. But by seeing the attitude of the IS officers, I do not think they will be paid once the content application is dropped. They say that the next day, by today night, pay all the by anyhow go to persons door to door and pay all them all the dues applicable to. And the concerned officers they had to run from door to door and they paid and they issued them checks worth rupees 1 lakh 2 lakhs like this, and people started crying. Sir, we have never seen 10,000 rupees in life, but we are getting check of 5 lakh. We don't have accounts in the bank. At that point of time, that Jandan account system had not come. So we were really, they were in tears. They said, we cannot, what is this check system? They had no idea about that. Anyhow, then there some persons rang me up, said they have given us checks. So next day I said that yes, they have paid the amount. So accordingly, content was dropped with that they have to be paid continuously. Ultimately, that writ application I finally had and it was allowed. Unfortunately, in some other areas, because the officers had appeared in persons, IS officers and everybody knows about the egos of these bureaucrats. So they started, they did not pay to the other pump operators working similarly in other places. Again, we filed it applications, and that went for about 7, 8 years. And there were also the interim order. Interim order is not implemented anything. Ultimately, recently a judgment has come by the Honorable Court, wherein the Honorable Court has said that no, you have to know nothing doing so far as minimum wage is concerned. No question of financial hardship and anything, because if you have got sufficient finance to throw away money in different schemes, and to but why we are depriving these poor workers? So that is the reason why I am giving this example, because this how this directive principle state policy have been entered into this Article 21, this particular, and how the courts have interpreted. I mean, interpreting Article 21, that they have the every right to live in a decent manner, and that is the reason I give this example. I'm sorry it took some time, but that is relevant while implementing directive principle state policy. The Payment of Wages Act 1936. This act was enacted to regulate the payment of wages to certain classes of persons employed in industry. The Payment of Wages Act 1936 governs how wages are paid to employees, direct and indirect. The state is intended to protect the employees from unlawful employer deduction and to unjustifiable salary delays. Because everywhere the management people that they do not look at the interests of the workers unless they are statutorily or legally bound. They will never know. Even today also that attitude is also there. No, very in exceptional cases only management looks at the interests of the workers. But most of the cases, if they are constitutional, legally and statutorily bound, then only they will do it. Otherwise not. The Code on Wages 1920, that is most important. 2020 Code on Wages. This act relates to amend the and consider the laws relating to wages and bonus on matters connected therewith or incidental thereto. The code provides for universal minimum wage across employments in organized and unorganized sector. The code mandates the central government to fix floor wage, and that the minimum rate of wages fixed by the appropriate governments shall not be less than the floor wage. Because floor wage is done because appropriate government, sometimes it is central government, sometimes the state government, because the concerns in state government under the state governments, they are under the appropriate government is the state government, so they have got their separate wages. Central government has got separate wages. For that reason, the government has in 2020 has come up with a code on wages. That has to be a floor wage, and no government is permitted to go below the floor wage. The Central Labor Regulation and Contract Labor Regulation and Abolition Act 1970. That is most important statute. That statute deals with the even hours of work, the holidays, and how many hours of work worker is required to do, and everything. And there's many aspects have been provided. And if the workers are continuing on different for years together, then there has to be abolition of the contract workers, and after contract workers abolition, they will be empaneled as regular employees of the employer. That is the intention of this 1970 Act. The Act applies to every establishment in which the 20 or more workmen are employed or were employed in any day of the preceding 12 months as contract labor, and to every contractor this who employs or who are employed on any day of the preceding 12 months, 20 or more workmen. Here there is a provision that it is the duty of the employer to see that workers are paid wages properly, because nobody can say that employer cannot say that I do not know who are the workers and how they are paid. That is, the statute clearly covers that. So the list of workers has to be given to the employer, and employer has a list of, and at the time of payment, it is the duty of the employer to supervise and see that each and every employee is paid his wages. So one short example I'll give with respect to our late Justice B.L. Hansaria, who was our Chief Justice of High Court, and also he was the judge of the Honorable Supreme Court. Once a case I filed because to my good fortune I have filed lot of cases for this workmen, and I've got orders in their favors by God's grace and by the grace of their lordships of this High Court and Supreme Court. In one case, way back in 1992 or 92, I filed around article 400 workers. I filed a writ application praying for regularization and for equal pay for equal work. Equal for equal work is there in Article 39D. I'll come later on. That equal for equal work, that is not enforceable, but applying again Article 21 and again applying Article 14 and 16 of the Constitution of India, I filed it application. And then the government came filed a counter. We do not know who these employees are. They are not our employees. We are not liable to pay any wages or equal pay, equal work. They are the employees of the contractors, so we are no way concerned. So they were the simple way they filed the counter. Then when the Justice Hansaria was having very much sympathy towards workers, Justice Hansaria. So what he said that Mr. Mishra, what is your answer to that? When there is a dispute came, the disputed question, we cannot decide in the writ application. Well, no, my lord, they cannot say so. If they so, then that executive engineer, the engineer who has filed shown the affidavit, will face prosecution. How? Then I brought in this contract labor regulation abolition 1970. Says that it is the how it is in section 29 of the it is responsibility of the act of the employer to see that who are the workers working in different the contractors or different agencies who are executing the work and how they are prepared. If they do not do it, then they will face prosecution. Sarah said that yes, Mr. R.K. Patra was the government advocate, then later on became just judge of the Honorable Odisha High Court and became Chief Justice of Sikkim High Court. That yes, Mr. Patra, call your executive engineer, will be prosecuted if he says that he doesn't know. Then Justice Patra said that no, my lord, let me give him some time to come with proper affidavit and all that. Then 2 days time was given. Thereafter, the executive engineer came with another affidavit. Said that no, these workers are there, and they said, so these workers are there, but they are working under contractors, so they are not intended for regularization. And ultimately, just the answer laughed after Mr. Patra said that, yeah, what is this? These two affidavits are run contrary to each other. No, sir, please excuse that affidavit is withdrawn. And just the answer allowed the directive for regularization of those 400 workers. Matter went to Supreme Court. Supreme Court also confirmed that. Ultimately, the workers got the benefit of regularization. So these are all the how these why I am saying these examples, because the examples have how in which manner the courts have treated this directive principle of state policy. Even Article 39D, that is a directive principle of state policy. 39D deals with equal pay for equal work, but it has been brought into the scope of Article 14 and 16 of the Constitution of India, and as well as 21, and then the judgment has been delivered. Then your also can see the payment of the bonus act. Payment of bonus is also very important, because bonus is a part, is a incentive given to the workers. The Payment of Bonus Act 1965. The act is to provide for payment of bonus to persons employed in certain establishment on the basis of profits or on the basis of production or productivity for the matters connected therewith. Actually, the bonus is all the workers, all the employees, they look for the bonus, because bonus they get some lump sum. They can meet some of their basic needs after getting the bonus. So everywhere people eagerly look for this like puja bonus in our eastern region. Dasara puja is an important function. So here the puja, during puja they get the bonus, and different they like Diwali bonus. In North India, Diwali is a very big festival. So during Diwali they get the bonus. So like this, it is the incentive to be given to the workers that is provided in the incentive in the act itself. Then Payment of Gratuity Act. A person works and works for so many years, for 35 years, then retires. The Payment of Gratuity Act 1972. That is also in furtherance of this Directive Principle of State Policy. Because Payment of Gratuity Act is clearly provide how much gratuity is to be paid. If an employee has to get, even a worker also will be paid gratuity, leave aside the government, even private on employees also will get gratuity under the Gratuity Act. That is there in the then directive based on Gandhian principles. Article 40, Organization of Village Panchayats. Thereafter the Constitution has been amended to incorporate this Article 40 composition of village panchayats in different The Constitution they added Part 9 of the Constitution is the section Constitution related to panchayats, that is from Article 243A to 243O. They have been incorporated by way of amendment in order to implement Article 40 of the Directive Principle of State Policy. What is the Article 40 says? The state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. So Panchayat Raj, Council of 5 officials, is the system of local self-government of villages in rural India as opposed to urban and suburban municipalities. It consists of Panchayat Raj institutions through which a self-government of village is realized. They are tasked with economic development, strengthening social justice, and implementation of central and state government schemes, including 29 subjects listed in the 11th schedule. So Part 9, of the Constitution of India, therefore has given this power. These articles, this Article 243A to 243O, the articles deals with the constitution, composition and duration of panchayats, powers, authorities, responsibility of panchayats, and all of the governance of the panchayats. So this thing has been incorporated in the constitution itself. Then Article 43. Article 43 states shall endeavor to promote cottage industries in an individual or cooperative basis in rural areas. Cottage industries, the promote cottage industry as per Article 43, the government has established several boards such as Village Industries Board, Khadi and Village Industries Commission, All India Handicraft Board, Silk Board, Coir Board, etc., which provide essential help. Like this, you can also say that this Amul, and in our state, Rompet, all these things are there. There's the cottage industries. And in Karnataka, it is Nandini, and the different states have got their separate. These are all cooperative societies which deal with these all these cottage industries, like milk industry and all that, and different industries. In Article 43B, that is also to promote voluntary formation, autonomous functioning, democratic control, and professional management of cooperative societies. The cooperative societies are active there in all the states. So cooperative societies, they have cooperative societies, banks are also there to provide benefit to the cooperative societies and the members of the cooperative societies. Because in cooperative societies, only members can get the benefit, not cooperative society banks can give benefit to the members only, not to outsiders. Article 46, then the promotion of educational economic interest of scheduled castes, scheduled tribes, and other weaker sections. The state shall promote educational and economic interest of the weaker sections of the people, particularly that of scheduled castes, scheduled tribes, and other weaker sections. Scheduled Caste and Scheduled Tribe Prevention Act 1989 is an act which clearly protects the interest of the scheduled caste, scheduled tribes. Besides the reservations and all that, I'm not going to the reservations basis. That is under different parts of the constitution. The act has been enacted to prevent the commission of offence of atrocities against the members of the scheduled caste and scheduled tribes, to provide for special courts for the trial of such offences and for relief and rehabilitation of victims of such offences and for matters connected therewith or incident thereto. And there is a clear provision that one is accused of such offences and entitled to get antecedent bail. Section 18 is very clear in that area. Then Article 47. Duty of the state to raise level of nutrition and standard of living and to improve public health. States are regard the raising of the level of nutrition and the standard of living of its people and the improvement of public health as among its primary duties, and in particular, states shall endeavor to bring out the prohibition of the consumption except for medicinal purpose of intoxicating drugs and which injurious to health. Actually, here in this case, they to avoid drugs, NDPS Act had come. Narcotic drugs and Act NDPS that substantive exactly NDPS Act. The NDPS Act intended to ban all these drugs like ganja, opium, and other charas and other things, and the punishment is quite heavy. And not only that, this Article 47 aims to see that even the liquor is also to be prohibited. But the thing is that this, since it's not enforceable, and liquor is a good source of income by all the governments. So governments, few except Gujarat government and Bihar government, I think Haryana government had introduced it, subsequently improved it. And the other governments have rather, they have been, instead of abolishing the drug, I mean the banning the liquor, they are rather introducing new and more subs, drug related, liquor related subs, and gaining quite good amount of money. And that is creating a havoc in the, especially in our old, middle, and young people. Young people are being distracted, and they are away from this by taking liquor and all that. There are a lot of accidents are taking place because of taking liquors and drugs. But unfortunately, this has become the way of life now. The liquor has become a way of life now. But that is the purpose that Article 47 has aimed at, abolishing the liquor system also. The Food Safety and Standards Act 2006. The Act is to consolidate laws relating to food and establish the Food Safety and Standards Authority of India for laying down science-based standards for articles of food and to regulate their manufacture, storage, distribution, sale, import, and to ensure availability of safe and wholesale food for human consumption and for matters connected therewith or incidental thereto. Prevention of Corruption Act 1954. The Act provides the protection from adulteration, contamination of food that may lead to health risk of consumers. This Act deals with the frauds also that can be perpetrated by the dealers by supplying cheaper and adulterated foods. Here, I may have a nowadays you can find in our state also we are getting a lot of adulterated food. This let us say ghee. In the name of desi ghee or dalda ghee, they manufacture adulterated ghee and supply in the market in the branded containers. Branded containers. So that way, the Prevention Order Act 1954 has been enacted, but unfortunately, that is not implemented seriously. I do not find very few people are really punished under this act, because this act, though provides for punishment, but there are many ways to get acquittal under this provision, because the authorities, they do not follow these compulsory the technical aspects of the provisions, which allows the courts to acquit the accused persons for non-compliance of the even. Nowadays, NDPS Act has become little bit, the people, officers have become very careful. They are following the from Section 42, Section 50, and other mandatory requirements. So that reason, the conviction rate is quite high in the NDPS cases. Then Article 14 prohibits the slaughter of cows, calves, and other meals. They dot cattle and improve their breeds. That is known to everybody how they are being done and all that. The directives based on liberal intellectual properties. Article 44. The states shall endeavor to secure for citizens the uniform civil code. That is a hot topic nowadays. But that is that was thought of by the constitution makers at that point of time. Uniform Civil Code is meant to replace currently applicable various laws applicable to various respective communities which are inconsistent with each other. These laws include Hindu Marriage Act, Hindu Succession Act, Indian Christian Marriage Act, Indian Divorce Act, Parsi Marriage and Divorce Act, Special Marriage Act. Besides that, the other special laws that Muslims have got separate laws. Separate laws means the Muslim law is there, and Muslim law, there is no codified law of Muslim law, but Muslim law is separate in there. They are governed by their own law, except Article 45, provision for free and compulsory education for children. States shall endeavor to provide within a period of 10 years from the commencement of this constitution for free and compulsory education for all children until they complete the age of 14 years. Of course, that has now been come into this periphery of the Act. The Child Labor and Prohibition of Regulation Act 1986, renamed as Child Adolescent Labor Prohibition and Regulation Act 1986-2016. This child labor prohibition of child labor as though has been promulgated, but we see everywhere the chotu child, the boy of 10, 12 years will come around with the glass of milk, and in any dhaba or any small restaurant you will find it. But unfortunately, we are not able to do anything. And if we say that why the child is working, unless child works, how the family will be the family will be fed. That is the answer their parents give. The Act to prohibit this engagement of children in all occupations and to prohibit the engagement of adolescents in hazardous occupation and process and matters connected therewith are incidental thereto. I have come across with cases where the child labor has been engaged, but their ages, because they are not very educated or not, their respective ages have been enhanced in the record. Say that yes, they are more than 18, but the child is of 12 or 13 years or 14 years of age. So they are being engaged in different factories also. Even now also they are being engaged in different factories. And they unfortunate the greedy management, greedy factory owners or greedy businessmen, they are utilizing their services at a very lesser price, taking advantage of the poorness of the families. Right to Children and Free Education and Compulsory Education Act and Right to Education Act 2009. This Act of Parliament was enacted on 4th August 2009, which prescribes the modalities of the importance of free and compulsory education for children between 6 and 14 in India under Article 21A of the Constitution. India became one of the 135 countries to make education fundamental right of every child when Act came into force on 1st April 2010. This Act makes education a fundamental right of every child between age of 6 to 14 and specifies norms and elementary schools. I doubt, though the government has come up with different schemes like midday meals and all that, but I doubt really this act is really implemented in letter and spirit. In Article 48, Organization of Agriculture and Animal Husbandry. To organize agriculture and animal husbandry on modern and scientific lines and shall in particular take steps for preserving and improving the breeds, the prohibiting slaughter of cows and calves and other milks and other and nothing much to say about the organization of agriculture and animal husbandry because the government have been coming with many schemes, many laws, but hardly these laws and schemes are implemented. Because every day in newspaper and the TV we see that workers, the agriculturalists, the farmers are destroying their vegetables. They say that it is better to throw it in the road by selling a tomato at a rupees 1 kg per rupees 1 kg per 1 rupee per kg. Like this, and the middlemen are getting always benefit because let us suppose we are buying tomato at a cost of rupees 40 rupees, but the actual cost the farmer gets hardly 5 rupees or 6 rupees. 35 rupees is distributed among the 2-3 intermediaries, and unfortunately we are paying 40 rupees, though worker the farmer is not benefited thereby. But the government is to do much more work on this issue. Then Article 48A. Protection of improvement of environment and safeguarding the forest and wildlife. To protect and improve the environment and to safeguard the forest and wildlife in the country. Environment Protection Act 1986. A good thing the government has done to establishing NGTs, National Green Tribunals. They are really doing their best to protect the environment. Though we have been destroying environment every now and then, it has been enacted in the year 1986. It has it was enacted with the main objective to provide the protection and improvement of the environment for matters connected therewith. The main aim was for protection of the environment and imposing penalties uh, uh, and punishments on those who are endanger environment for safety and hazards. Every state you have got pollution control boards. Though there are a lot of allegations are coming for their corruption and all that, but still these environmental measures are being followed, and courts are very strict on implementing these laws. Normally, neither High Court nor Supreme Court are giving any leeway to give this benefit to these persons who are violating the environment or environmental laws. Then Wildlife Protection Act 1972. This act which provides for safeguard and protection of wildlife, flora and fauna in the country. This is an important legislation and forms an integral part of the environment and ecology and provides for protection of the country's wild animals, birds and plant species in order to ensure environmental and ecological security. This Wild Protection Act, though it is being followed, but still a lot of poachings are being done nowadays. Oh, even earlier it was done, but nowadays it will reduce a little bit. But in our state especially, we always every day we see news that elephants are poached, tigers are poached and all that. So tiger population is decreasing day by day because of this poaching and all that. Because not only these other animals are also the birds. The people you have got a largest lake in Orissa. There is Chilka Lake. That is one of the largest lake in Asia. next to Bamband Lake. So that lake, in the winter season, lot of migratory birds from Siberia and all that, within the thousands of miles, they come and come to this lake. Unfortunately, these hunters, they kill these birds and sell it in the market, and the people buy it and at a very high price. And they very difficult to control them. The government has been trying to control them, but still they are on the job, and they are able to do it to some. Though it has been reduced to some extent in recent years, but certainly still that is being made available, or the hunters are running free. And so that then Indian Forest Act. It aimed to regulate the movement of forest produce and the duty leviable forest produce. It also explains the procedures to be followed for declaring an area as reserved forest, protected forest, or a village forest. The need for legislation protecting the regulating forest was required, which was made by the Indian Forest Act 1947, imposing government control over forests and classifying them into reserved, protected, and village forests. Forest are naturally we are not taking sufficient steps to create forest, but are destroying forest in the name of the development. But that is the reason why we are now getting a very high temperature because of the this destruction of forest. Anyhow, but development is necessary, but at the same time, it is also necessary to create forest. In Orissa, our state government has made a record growth of creating forest, more than 400 or 700 some hectares of forest in last year. And that's the reason why the government has been awarded for this purpose. Article 49, protection of monuments and places of objective and of national importance. It shall be the obligation of the state to protect the every monument, a place or object of artistic or historic interest declared by or under law made by the parliament to be of national importance from spoliation and disfigurement, destruction, removal, disposal, or export, as the case may be. This national importance, these national ancient and historical monument, archaeological sites, Human Remains Act 1948. This act has been promulgated by the government of India to protect these monuments. The act has been enacted to protect the monuments, places, and objects of national importance. That is the act to provide for preservation of ancient and historical monuments, archaeological sites, and remains of national importance for the regulation of archaeological excavations and for protection of sculptures, carving, and other like objects. So, Archaeological Survey of India, which has been constituted, which is formed by the government of India, actually doing their best to protect the archaeological sites of India. And most of them are also been treated as the recognized with the world also. Then Article 50, the state shall take steps to separate judiciary from executive in public services of the state. That I need not say because though it is stated that they have the judiciary and executive is separate before CRPC 1973 came into force. Before judiciary and executive was same. But in 73, first time they came out with a distinction: the judicial function, the differentiated judicial function and the state functions. So that is in 73 in CRPC 1973 brought that independence. I'm sure this independence related to lower judiciary, not higher judiciary. Higher judiciary is independent from day one. The lower judiciary was not independent, or it was mingled with this state agency till 1973. Then Article 51. Promulgation of international peace and declares to establish international peace and security of state shall endeavor to maintain just and honorable relation with the nation, foster respect for international law and treaty obligations, encourage government of international dispute by arbitration. This, I think, the present government especially has been, or even previous governments also, they have been maintaining this. They are trying to maintain this good foreign relationship. This Article 51 is almost followed by all the governments. Then amendments in the right to principle of state policy. How amendments came into force in 42nd Constitution Amendment. First it came in 1976. The introduction, it introduced certain changes in Part 4 of the Constitution by adding new directives. Article 39A to provide free legal aid to the poor. Free legal aid that has become a revolution now. Now, legal aid authority is constituted in every state and also state, and the poor persons are getting legal aid by the legal aid authority, and that is being controlled by the different high courts and also by the Supreme Court. So they have got a separate board for that, and separate the senior most judge or Chief Justice of India become the chairman. All these things are legal aid provision. People are getting legal aid to a lot extent, and they have got their legal aid. They have got their panel of lawyers, and most of the panel of lawyers are trying their best to give the legal aid in to spirit to the poor. Then Article 43, participation of workers in management of the industry, as I already said, the Article 43, but that was introduced in 1976. The 48, protect to improve the environment, that was also introduced in 1976. Then 44th Amendment in 1978. It inserted Section 2, Section 2 to Article 38, which declares that state in particular shall strive to minimize economic inequalities in income and eliminate inequalities in status, facilities, and opportunities not amongst individuals but also among the groups. It eliminated the right to property from the list of fundamental rights. Though amendment has been introduced in the Article 300A, that is at 300A, wherein it says that nobody can be deprived of his right to property without due process of law. So, but previously it was fundamental right, that right to property was a fundamental right, but that was amended, and no more it is a fundamental right to property is a fundamental right. But by due process of law, right can be tinkered with. So, but this principle has not been very difficult to implement this principle, and nowadays we say that rather the rich is becoming more richer and poor is becoming more poor. I do not know the poor is becoming more richer and poor or not, but rich is becoming much more richer because of this benefits of different economic environment. 86th Amendment of 2002. It changed the subject matter of Article 45 and made element litigation a fundamental right under Article 21A. 21A into the Constitution is seeking to provide free and compulsory education, but that was incorporated in as a fundamental right. It is 6 to 14 years. Then, 92nd Amendment of 2002, Article 43B, which directs the state to strive for promotion of the appropriate promotion of the cooperative society, which added by 97th Amendment of Constitution of India. The conflict between fundamental rights and DPSP. Associated cases. I'm just not. Sorry for a minute. I'll just, because already it is around more than 1 hour, so I should not take more time. But the Champagaram Doira Ranjan versus State of Madras, they had 50 on Supreme Court, where conflict between fundamental right and principal state, which I have already explained. Then Goloknath versus State, wherein that is a famous case of 1967, is that where provided the fundamental rights could not be amended by the Parliament even for implementation of directive principle state policy. By that doesn't. But subsequently in Keswanand Bharati case in 1973, that was changed. Supreme Court overruled the Goloknath case and directed the Parliament can amend any part of the Constitution, but it cannot alter the basic structure. That law is still there even today. So then Minerva Bill versus Union of India. Here 80 Supreme Court 17287. In this case, Supreme Court reiterated the Parliament can amend any part of the Constitution, but it cannot change it. The same thing was reiterated. Then right to health. Then I'll come to right to health. The right to health has been possibly the least naughty area of the court in terms of justifiability, but not in terms of enforceability. Article 47 of DPSP provides that for the duty of the state to provide public health. However, the court has always accepted the right to health as being an essential part of the right of life. Parmananda Khatara versus Union of India 89 for SSC, the Supreme Court held. Principal got experienced in the case of an agricultural laborer whose position after a fall down from running train deteriorated very much. When as many as 7 government hospitals in Calcutta revolved to admit him as they did not have beds available, the Supreme Court did not stop at declaring the right to health to be a fundamental right and at enforcing the right of the labor by asking the government of West Bengal to pay him compensation for the loss. Then National Health Mission encompasses in 2 submissions: National Rural Health Mission and the National Urban Health Mission. And then Ayush. Ayush is an acronym of Ayurveda, Veda, Yoga, and Naturopathy, Unani, Siddha, Homeopathy. And there are 6 Indian systems. But I need not say this because no time is not there. But Ayush is a very important scheme of the government. By just it is being implemented, and people are also getting a lot of benefit out of it. The right to education I've already stated, and the support relevant support judgments. The important support judgment is and Mohini Jain versus State of Karnataka, 1992, CSCC 666. Current decision was also examined by a larger bench of 5 judges in Unikishan JP versus State of Andhra Pradesh. And then thereafter, equal paper, equal bar, which I was saying was the 39D of the Constitution of India. I'm denoted a few cases. The Dharwad District PW Literate Daily Wages Employees Association versus State of Karnataka, AR 91 Supreme Court. Ranthir Singh versus Union of India, 82 Supreme Court 879. Nevaram versus All India Institute of Medical Science, 18 Supreme Court 957. And latest judgment is also there. A lot of judgments are there. It's only recently latest judgment we missed. In mistake, I could not get the print out. Federation of All India Custom and Central Exchange Stenographers versus Union of India. What is this concept of equal pay, equal bar? Court has interpreted in accordance as a fundamental right and between with considering Article 14 and 16. Constitution equal pay for equal work, they're the same place. The 2 persons are working, doing the same work. They're entitled to equal pay. Even the government regular employee is getting, let us say, 50,000 rupees, but a contractual employee is getting 12,000 rupees, or another delivery person is getting 13,000 rupees. But Supreme Court has made some deviation in that year. Not that every case equal pay for equal bar maintained, merely because he's sitting on the same bench or same the side by side chair. That doesn't mean that he will be entitled to get equal pay for equal bar. Then the degree of responsibility, the Supreme Court has said that it's a degree of responsibility, degree of work, the nature of volume of work, and accountability. All these things are very much important. The accountability, the daily wager may not have that accountability and the degree of responsibility with that of the regular employees. So it is the person who claims equal for equal right, though he can claim as a matter of right within the Article 14 and 16 of the Constitution of India. But he has to prove that the degree of responsibility, the degree of the nature of job, the working hour, and the accountability, everything is same with that of the regular employee who is getting more salary. So unless he proves that, he will not be entitled to get. Fortunately, I have conducted up to number of cases in this right to equal pay for equal right up to the Supreme Court level, and we have succeeded in all cases because by looking at the law, we have made out a case accordingly. You have wherever we have not been able to make out case, naturally we have not got it. But hardly 1 or 2 cases I have failed, but almost of 99% cases I have succeeded because of this. Because knowing the law, I have put my case within that. I have got the documents under RTI Act. Or even before RTI Act came into force, I got the documents otherwise by different sources and said that though it is not on, I have got document from a reliable source by this, because the government document you cannot file it. So unless, and there also we have filed some petition to call for the records from the government, and the government has been compelled to give the records By this process, equal favor, equal right has gone far ahead. The courts have recognized that right like anything, and people, workers have got a lot of benefits. Then this is under Article 39D of the Constitution of India. Then implementation of DPSA associated acts and amendments. Land reforms. Almost all states have passed land reform laws to bring changes to the agrarian society and to improve the conditions of rural masses. These measures include abolition of intermediates like jamdars, jagirdars, inamdars, etc. Tenancy reforms like security of tenure, fair rents, etc. Imposition of ceiling on land holdings, distribution of surplus land among the landless laborers, cooperative farming. These are all bonded labor System Abolition Act 1976, the MMDR Act 1957, which is Panchayat Raj. And recently I got because I also do cases of mining mine owners as well as the local villagers. So the local villagers in mine areas, the mine owners are getting hundreds of crores every year out of the mining business. But unfortunately, the local people are not getting even the employment in the local area, local in that mining also. And there is a statute, the government has, there is a provision is that the fund collected from miners, so mining owners will be spent for this. Supreme Court has delivered a judgment. High courts have also got delivered judgments, but unfortunately, these things are not being implemented properly. So the villagers from where the nearby villagers were nearer to these mining areas, they are living a miserable life. Most of them are living miserable life, and that too, they are also subject to this high pollution level because of the mining areas. Unfortunately, that part the governments have not been able to do it, maybe consciously or unconsciously. Then Panchayat Raj system, already I have stated, education also, the rural area development, um, rural area development programs such as community development programs 1952, integrated rural development program 1978-79, Mahatma Gandhi National Rural Employment, that is called Manrega 2006, were launched to raise the standards of living, particularly in rural areas, as stated in Article 47 of the Constitution. Actually, what happens in this area, in this COVID-19 pandemic situation, this Manrega had helped like anything to provide to food to the people, and because there is a lot of unemployment at the states. Health. Central government some schemes, that is Pradhan Mantri Swasthya Yojana and the National Rural Health Mission. Because of this Ayush program and all the time, the government has been providing health benefit to the worker, to the employees wherever they are applicable. And our state government is also has come with a health scheme which provides 5 lakhs benefit to the workers, sorry, to the persons who are really who are below the poverty line, and 10 lakhs to the women. So this way, the governments have been trying to implement that benefit to the needy workers, needy persons, needy citizens. The concept of DPSC need not say about all these things because they already said all these things. Then features of directive principles, I also need not say because there are amount of repetitions. Now will come to criticisms. There are criticisms of directive principles state policies. In a short, I'll say lack of legal force. The critics argue that there is a lack of legal force while implementing these directives. The violation against these principles cannot be challenged in any court. People say that because it is not here, it is a merely paper, nothing, it is there on the page, only academic, it has no legal force. But I have already explained earlier that how, even if it doesn't have specifically does not legal force, how the different legislations, the governments have been legislated this incorporate these policies into the legislations, and also sometimes how the courts have entered into the scope of Article 14, 16, 19, and 21 of the Constitution of India. These principles. The non-justiciable, the Convention did not make them justiciable, neither fixes the time limit with which they are to be secured. They are more declaration of intentions which should be fulfilled by the state. According to the critic T. Shah, they are a check payable by the bank at its convenience. Mr. Shah, the noted critic, said that, oh, you have given a check, but it can be paid when the bank wants. So that check, the bank doesn't want, then the check cannot be encashed. You are having the check, but you cannot encash it. Lack of clarity in DPSU, that is, these are the criticisms. For example, directive principles to aim to promote international peace and friendly cooperation among all the nations lack intelligible guidelines for its implementations. That it is wisdom, it is the government's, respective government's wisdom how to implement it. There is no guideline provided for this particular implementing this. There is no clarity or guideline to implement this policy. Then non-practical. Some of the principles are not practical in nature, but for include some directives which cannot be implemented in the actual practice. Haryana introduced a prohibition but found it almost impossible to implement. The Haryana government also therefore compelled to scrap it. In Bihar government also, the Gujarat government, it is there, ban is there from the day one, but unfortunately the neighboring state, Daman and Diu, they have got a lot of liquor shops. So I'm told that the persons who who really are interested in drinking, they go to nearby state and get the liquor from them, from those states. And also that in the hotels that is rampantly available, as I am told. I do not know. I'm not very. I don't have personal knowledge on this. But so far as Bihar is concerned, we see in the recent past, lot of deaths have occurred due to spurious liquor, because when people are accustomed to liquor, so people cannot stay without liquor, so they are being prone to this consuming spurious liquor, and they're losing their they're losing their eyesight, they're losing their health, everything. Then age-old should be criticized that due to incorporation from age-old and foreign philosophical foundations based on Fabian socialist and almost lost its relevance in present day world. Present day world. Actually, what happened, as I said, how it came from Irish constitution and Spanish constitution and all the Sweden and all that. And therefore, it is critical that it has been imported from foreign. It is not practical, and but I say that it is really practical, and it has been practically been implemented by different governments and different from different points of time. Not that this criticism is not acceptable at all. The critics may say always criticize for anything and everything. The directives were designed to serve pious promises for creating an impression that just and useful exercise of the power of the power of the state. They aim to secure support for making promises and not through action. So it is that it can only they can only make promise, but it cannot be followed by. You cannot enforce it. You cannot compel them to keep up the promise. The promises are always like election promises. Election promises are made but not been fulfilled. Most of the election promises are not fulfilled until that next election comes. Like this, they say that these are nothing but promises. So that is the critics say that this should have been incorporated in the fundamental acts so that it could have been implemented or it can be enforced like the constitution makers to their wisdom had deliberately kept it to for this purpose as it is, because they are of the opinion that respective government should do well to do it, because everything they make it in fundamental right. It may become very impractical for the government to work on it, because the government's to fundamental right means the government is bound to do it, or so if the government is not able to do it, then it will be a lawless society. That is the reason why they have deliberately thought of this directive principle of state policy. As I have read the concept of the preamble laid down by Dr. Ambedkar in the beginning, while promulgating constitution or providing this directive principle of state policy. Like this, there should be so the directive principle of state policy plays very important role, and it has gradually come to the mainstream. Not that it has not come. Some portions have left, but gradually, in course of the courts are trying to do it. Governments are also, respective governments are also trying to do it, and more need to be done by the respective governments and also by the courts. And because it is already 1.5 hours, so I need to say about the conclusion part. So I think if you have got any question, we'll answer. So this is how the directive principle of state policy.
So,
I would love to speak, but because of the time constraint, I could not say.
so we had this discussion in the chat box also that we just did not think it appropriate to interrupt you, because I think that by far this is going to be the most informative one session on directive principles there can be. So you have gone through such intricacies of the law in such detailed manner that I know that for sitting with this for this particular class, I think it will require everyone to go through it again and at multiple points in time and with the constitution and a proper computer to search very detailed, so absolutely very enlightening.
Thank you.
I had prepared, sir, a lot of questions, I'll be honest with you, for the class, and all of them you answered, sir. Every single question.
Thank you. I was afraid for questions.
But irrespective, sir, still, because obviously we're also advocates, it's our duty to still figure out something.
But it is normally it is my style. I always I argue a case in High Court, in Supreme Court or other High Courts. I always trying to know what is the main case of the opposite party. So in course of my argument, I answered that argument. So I at least that is there in the mind of the judge that, oh, this will be the argument of the other side. So this will be the answer. So before giving this answer, so that way I try to bring it in my on my side. When the other side starts argument, he becomes defensive. He becomes defensive. He tried to argue that, but by that time I have already answered it. So it has already, that question has come in the minds of the, because otherwise the court will think that, oh, what other side will argue? Other side will argue that. Then he will say, oh, this is the argument. And then Mr. Mishra has not argued this point. So naturally, that will his attitude. Let us suppose he has my court is carried in my way, but certainly the court attitude will be changed against me. That is the reason why I always try to answer it. Answer the what main argument will be done by the other side. That way, I try to get leeway from and get a better judgment in my favor. I try to.
So this is actually one more thing which the reason why we're doing all of these classes is that so that people may all young advocates mostly at least that they may get this idea about what are the various manners of proceeding with the case. So what you've just mentioned right now, this is very insightful information and very useful. I know for sure that I'm going to apply it in my cases, and I can see the merit. I am lost for questions, sir, right now. Very few questions, but obviously the kind of now it's like not all details and nitty-gritties are gone. Yet there is a lot of inquisitiveness is what I think intrigues me the most, because you mentioned so many things that at this point itself, if I have to ask you a question, then I think I'll probably the best thing which I will want is another date. And I'll say that, sir, all of these topics that you have gone through one by one, so please let me come back to you on the next date for picking up probably say 1 or 2 points. Like so much you took us through all the articles extensively through the directive principles, simultaneously what all legislations have been born out of all of them, what have been their impact, what has been the various benefits that have come out of it. So all of these were my questions that how have they been impacting my life, what has manifestly come out from that, whether if amendments are allowed, what kind of amendments and how, but absolutely fantastic. So again, sir, considering that it's already been quite long, just one very small question, sir, which is there by Mr. Weber. Weber, would you want to ask your question now?
Yeah, hello, sir.
Hi, Weber.
Yes.
So, sir, I want to ask like that, sir, like you said that fundamental rights create a burden on the states, like they're enforceable by law, but
Yes.
DPSPs are not.
Yes.
So, sir, if we make the DPSPs enforceable, then it will create a burden on state, but it will help in the recognition of individuals, minorities, and rights of general public. So, sir, if DPSPs are made enforceable, will there be a positive effect on litigation against the state, working of state, or benefits of the individual, or it will rather be a negative effect on all the points?
No, it will have a positive effect, certainly. Certainly, there will be a positive effect because a lot of persons will get a lot of benefits. But sometimes it's made difficult to make these principles compulsory, because the lot many aspects are there to make it compulsory or make it enforceable. That is the reason the constitution makers consciously had not done it enforceable. But in this process, as I said, different governments at different points of time had made it, different courts have also incorporated this in form of Article 14, 16, and 19 and 21 of the Constitution of India. Most of the policies now are become enforceable. Most of the policies are being enforced by different legislations, different statutes, and different judgments also, by incorporating, like I said, the recall for recall. That is not enforceable. But courts have made it enforceable by incorporating, by bringing it to within scope of Article 14 and 16 and 21 of the Constitution of India. By this process, most of the most of the policies and the principles of directive have been incorporated or come to the mainstream. Most of it. Few are left, but I think few can be, in course of time, it will also be brought to mainstream.
Sir, I have a follow-up question, if you permit.
Yes, yes.
Sir, there's a concept of equity, like there's equality, and equity is providing with equality, but with some other features, or implementing the basic needs, like equality, giving everybody equal, and equity, giving everyone as per their needs. So, sir, Constitution overall talks about equality, but when the DPSPs come into the act, they provide for the less, they provide for the minorities or less deprived people or more deprived people. So, sir, how this affects the concept of equality and equity if taken together?
Minorities are protected at different positions of the Constitution. Minorities are provided protected in different parts of the other parts of the Constitution, like Article 30, different reservations, and many other statutes also. So, and equality, equality has a different courts. Supreme Court has interpreted equality, like Article 14, especially. Article 14, as the language says, yeah, I think I refer. There is a lesson on Article 14. Then it will take 2 days, because Article 14 has been scope of Article 14 enhanced to that extent that. But Article 14, as I said, it encompasses everything. Even let us suppose if there has to be, as you said, the basic language of Article 14 is the equality before law. But equality before law is a very large subject, and it is very difficult to implement equality before law. But by different statutes, we can include it, or you can bring this here. And let us suppose the equality, you can say that. As I said, this Article 39D, while implementing 13 equal for equal work, that is a form of equality. There, Supreme Court has categorically said that what can be in all cases cannot be equal. If there will intelligent difference here. Also, Article 14, while Supreme Court is interpreting the Article 14, I said that intelligent difference can also be made. But different, same class of people, different scheme, different provisions can be provided, or different benefits can be provided, based on the intelligible difference here. So that different judgments have come up on this issue. So it's Article 14 is being constituted, is being from day one and day to every day, almost every day, Supreme Court or High Courts are coming with this interpretation Article 14, and everything is coming other than Article 14. Article 14 has become a large subject, but now a lot of judgments have come under the Article 14. So, so that way it made. So anything more?
Thank you.
Weber, thank you so much for your question. So there is one last question, if you permit.
Yes.
So this is from Mr. S.P. Singh. Singh साहब, आप पूछना चाहते हैं सवाल? Or should I ask? Mr. Singh?
Yes, sir. Actually, first I must thank the all stakeholders, and I think it was a very good talk which sir has arranged, and he has given a valuable time to all of us.
Thank you. Thank you.
And especially because all points are covered up being a welfare state. So just I have a query.
Yes.
See, as Mr. Sir was telling, there were the workers we were less paid, and even the IAS officer, in spite of the court orders, they were not paid the sufficient compensation or amount salary.
Short me, sir.
And sir has done this thing. So is not there any provision that if there is a delay on the part of the administration regarding payment of the benefits of a employee, either maybe some areas of the promotion or any lesser dues or even a gratuity, even the pension, so there should be provision for recovery of such dues from the pay of the salary of the officer. How the administration will be, even all provisions are there. Every time a employee can't go. And as our Honorable Supreme Court has said, the biggest litigant is the government. So why for small tasks we are going to the courts? Why? Where we are heading?
Mr. Singh, you have raised a very good pertinent question. And actually, so far as pension is concerned, now the governments have come up with that the delay in pension due to laches of the officials, then the state will be liable to pay 18% interest. That is the circular of our state government, so also the central government. So it's 18%. But unfortunately, that is not implemented properly in lateral spirit. But anyhow, because of the delay and all that, what happens? The courts, after the orders are implemented, courts are also becoming lenient. They are not punishing the concerned officials or concerned persons who are the source of. I will give another example. A poor lady, a widow, her husband had died in 1982. And thereafter, she had filed cases and all that. Fortunately, we are not taking any fees from not taking fees from her. But anyhow, ultimately, after 23 years, she got her dues. And there the court said that you pay her interest of the 8% per year. And that order was confirmed by everyone. And the concerned officers, when the government had to pay 8% interest with all the dues with 8% interest. And it also directed that to recover that some interest from the hearing officials. I think government is doing its best to implement, but it depends on the person concerns, the court concerned. The court is insisting upon the even Supreme Court, even somewhere High Court imposed cost, or High Court imposed, Supreme Court said. So by this process, the court officers are put to different tasks by the courts. I think these things will be limited to a great extent.
Actually, sir, you are right. Actually, because until unless we are fixing the responsibility, a government official is fixed up even a small irregularity on this thing. Either it may not be the malified intention, for bona fide mistakes, he is punished. But here, what we are doing, the state administration, which has to implement the policy of the welfare state, they are sitting on the files, they have closed their ears and eyes. And this is one of the example. Other example, I came to know, there are many of the cases of deletion of votes from the voter list during 2022 without issuing the notice to that concerned person. The person is not neither shifted nor he has died. And it is a provision under the law that if you are deleting the vote of the any person, first you have to issue, the district administrator, DM or SDM, they have to issue the notice in writing. These are the regularity.
If I may just very humbly interject. We cannot speak about hypothetical situations.
Responsibility. No, sir.
No. Mr. Singh is right.
I can give the instances.
I understand. So that conversation, I think we can have separately also. So, but whatever pertinent question, absolutely.
Sir, injustice, sir, as it is said, injustice anywhere is a threat to justice everywhere. Martin Luther King, if any of the cases is sufferer, okay, it is rightly said, if any criminal is spared, that is good. But a poor guy should not be pressured. This is the natural law of the justice.
अभी सिंह साहब जैसे सर ने एक बड़ी अच्छी बात की थी
You are correct, Mr. Singh, but what can be done? It can be remedied through court only, but one has to approach the court only.
Sir, we have the great hope that the person like you and Weber, Kesav sir and you people, the all stakeholders which are arranging this beautiful town, we are able to hear you. The very and we could see, we could learn a lot about a rich experience of 43 years. 43
Thank
years.
you very
You are
much, Mr.
calling from Odisha, sir. Thank you, sir. Thank you, sir.
Thank you, sir. Manoj, sir, again, sir, I know for sure that there is going to be so much intrigue about this one particular discussion which has happened today. Sir, this class is absolutely all encompassing. As per my understanding, it's like a book. If someone can actually go through this session in a very detailed manner, it's actually like a book which is going to answer so many questions and going to help so many young lawyers understand what exactly is the framework. So just one final thought that I want to clarify with you is that is this statement, would it be correct to state that whereas the fundamental rights have a socialistic approach towards a person's life, the DPSPs, they have more of an economic ramification, so to say.
Economic ramification, but it has got social ramification also. Economic ramification is a part of it. Therefore, I did that three basic principles of this year by divided in the Kandian policy, this year policy by divided into three policies because of that only. Three classifications. The DPSP based on the basically three things, the three policies there. That is the socialist principle, Kandian principle, and liberal and intellectual principles. The three principles have the basic basis of this directive principle state policy. So basically, it has the economical is a limited part of it, but it is more of social and other policies like environmental policies, social policies. Economic policy is very limited part, not very much. But the thing is that but anyhow, lot many things have been done by the different courts and different governments by incorporating those legislations and different judgments. But still, more things to be done. More things are required to be done because a lot of things are different provisions have to include incorporated. Different laws have to be enacted again to incorporate all these. If the laws are enacted, then become enforceable. Automatically become enforceable. By this process, this directive principle thereafter can be deleted from the constitution also. If everything is incorporated in the different legislations and different judgments, I think directive principle state policy can be deleted from the constitution also. But at least I said that 50% have been brought into the mainstream. More than 50% have been brought to the mainstream.
And sir, you demonstrated that through your entire session today, sir, which was absolutely wonderful. I am grateful to you, sir. I thank you on behalf of all of the participants who are here.
I had a lot of examples, my personal experiences of conducting cases, but unfortunately the time is very limited, so I could not do it. Many more examples are there.
So next time, if it is possible, and I'll ask everyone also in this respect, that would it be better if we have a class more on relying more on examples? Because I think that is something which people pick up very easily.
Basing on the case laws and all that.
Yes,
The
case laws,
basically case laws. Basically, how the courts are brought. Now we have given the basic outlines, but that will be a difficult year. Anyhow, it will try to sometime.
We'll probably, sir, with your blessings, we'll try that also. We'll try to see how that also turns out. But sir, for today, I thank you so much, sir.
Thank you so much.
It takes a lot of work and so much time of yours you've given us today. I thank everyone who has been here today. I hope and I'm quite sure that there has been substantial learning for everyone. And so on behalf of our team, I thank you and I sir, request you that probably, hopefully someday soon, we'll have another discussion with you on similar lines. Hopefully some different topic, but as we just mentioned, sir, that probably something which has anecdotes or on an anecdotal level. So, with your blessings, I'll take your permission to close the class.
Thank you.
Thank you so much, everyone. Thank you, sir.